When can a plaint be rejected? Supreme Court clarifies Order 7 Rule 11 CPC in Karam Singh vs Amarjit Singh and others in its SC judgment dated 15 October 2025. Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In today's video, we will explore a recent landmark decision of the Supreme Court of India, Karam Singh vs Amarjit Singh and others, decided on 15 October 2025 by a bench comprising Justices J.B. Pardiwala and Manoj Misra. This case, officially cited as 2025 INSC 1238, Supreme Court of India, stands as an important judgment that clarifies the legal position on this issue. The focus of this case is the threshold power under Order 7 Rule 11 of the Code of Civil Procedure, 1908, CPC, specifically, the power to reject a plaint. We will cover the facts, issues, legal framework, the court's reasoning, and the practical takeaways for advocates and litigants. 1. Factual background and procedural history. The appellant plaintiff is Mr. Karam Singh, along with a pro forma co-plaintiff. The respondents' defendants include Mr. Amarjit Singh and others. Suit number 424 of 2019 was filed by the plaintiffs on 31 May 2019. The reliefs claimed in the plaint were: 1. Declaration that the plaintiffs are owners of the suit land to the extent of their shares, and further that certificate number 277 registered on 12 January 1977 and mutation number 1377 are null and void. 2. Possession of the suit land to the extent of their share. 3. Damages mesne profits for use and occupation of the suit land for the period from May 2016 to May 2019. 4. Permanent prohibitory injunction restraining the defendants from interfering with the suit property. The factual timeline of the land dispute, selected key dates. Original owner, Ronak Singh, alias Ronki, died intestate on 5 October 1924, leaving widow Kartar Kaur. A gift deed by Kartar Kaur to one Harchand was challenged. On 22 March 1935, the civil court held the gift invalid. On 11 September 1975, a decree held Kartar Kaur as owner in possession. Mutation in her favor was sanctioned on 13 May 1976. Kartar Kaur died on 28 December 1983. The defendants in mutation proceedings claimed a will dated 15 December 1976 in favor of themselves. The mutation litigation continued for decades and finally concluded against the plaintiffs on 20 July 2017. The defendants filed an application under Order 7 Rule 11, D, CPC seeking rejection of the plaint on the ground that the suit appeared on its face to be barred by limitation and for other reasons. On 7 January 2020, the trial court rejected the Order 7 Rule 11 application, holding that limitation was a mixed question of law and fact and thus could not be determined at the threshold. The High Court, in revision, allowed the application ex parte by order dated 27 January 2022 and later dismissed the recall application on 4 July 2022. The matter came to the Supreme Court, which heard the appeal and gave its decision on 15 October 2025. 2 legal issues before the court. The Supreme Court tackled the following core issues. 1. What is the correct scope of the power under Order 7 Rule 11, D, CPC, especially the extent to which the court may consider limitation or defense pleas at the threshold of the plaint. 2. Whether the plaint in this case disclosed a cause of action and whether the suit was on its face barred by law from the face of the plaint and thus liable for rejection under Order 7 Rule 11, D. 3. Whether the fact scenario of a claim for possession based on title, which falls under Article 65 of the Limitation Act, 1963, and the mutation litigation prior thereto meant the plaint was barred by limitation or barred under Order to Rule to CPC, earlier suit pending decided. 4. Whether the High Court erred in rejecting the plaint at the threshold, treating limitation and defense issues as though they could be decided on an Order 7 Rule 11 application. 3. Legal framework. Order 7 Rule 11 CPC and Limitation Act. Order 7 Rule 11 CPC reads, in brief, that a plaint shall be rejected in the following cases. A. When it does not disclose a cause of action. B. when the relief claimed is undervalued and the plaintiff fails to correct the valuation. C. When the plaint is proper but insufficiently stamped and the plaintiff fails to produce the requisite stamp paper. D. When the suit appears from the statement in the plaint to be barred by any law, including limitation. E. When the plaint is not filed in duplicate. F. When the plaintiff fails to comply with Rule 9 of Order 7. Important, the proviso clarifies that extension of time for correction of valuation or stamping may be granted only when the court records reasons and grave injustice would otherwise follow. Limitation Act, 1963. Article 58 to 3 years for a suit for declaration of title, or any other declaration. Article 65 to 12 years for a suit for possession of immovable property based on title, from when the defendant's possession becomes adverse. Key precedents. It is settled that the power under Order 7 Rule 11 is drastic and must be used sparingly. The court's inquiry at that stage is limited to the pleadings and documents annexed, and cannot go into the merits of the case. A court must not treat an Order 7 Rule 11 application as a mini-trial. C.T. Arivandantham vs. T.V. Satyapal, 1977 4 SCC 467, cited in this judgment. If a suit includes multiple reliefs and at least one relief is within limitation, the plaint cannot be rejected under Order 7 Rule 11, d. 4. Supreme Court's reasoning and key observations. Here are the major reasoning points from the Supreme Court. A. Scope of Order 7 Rule 11, d. The court reaffirmed that the rejection power under Order 7 Rule 11, d. must be exercised on the face of the plaint, i.e., only the averments therein, and documents exhibited with it, can be looked at. The court cannot consider the defendant's written statement or external evidence. While considering rejection, only the averments made in the plaint and nothing else is to be considered to find out whether the suit is barred by law. At this stage, the defense is not to be considered. B. Mutation proceedings and title. The court emphasized that mutation entries do not confer title. They serve a fiscal revenue purpose. The plaintiff's averment was that the mutation litigation ended only on 20th July 2017 and their suit was instituted in 2019, hence the suit was within a reasonable period from the termination of mutation proceedings. C. Possession-based relief and limitation, Article 65. Because the suit prayed for possession based on title, Article 65, 12 years, applied. The defense argument about adverse possession and limitation was a mixed question of law and fact, which cannot be decided at the threshold of Order 7 Rule 11. The court held that simply because the underlying will was older did not automatically render the suit barred. The fact scenario required evidence and trial. D. Multiple reliefs principle. The court held, where several reliefs are sought in a suit, if any one of the reliefs is within the period of limitation, the plaint cannot be rejected as barred by law by taking recourse to Order 7 Rule 11, d. of CPC. Therefore, even if the declaratory relief under Article 58 might appear time-barred, the presence of a possession claim under Article 65 kept the plaint alive. E. Bar under Order to Rule to CPC, earlier suit. The defendants argued that a prior suit, Civil Suit Number 648/2012, filed by the predecessor was such that the present suit was barred under Order to Rule to CPC, res judicata or issue of previously decided suit. The earlier suit's plaint was rejected under Order 7 Rule 11 and not tried on merit. The court held that such a rejection is not prima facie a bar under Order to Rule 2, the issue must be examined in trial. F. Final order. The Supreme Court allowed the appeals, set aside the High Court's orders dated 27 January 2022 and 4 July 2022 rejecting the plaint, and restored the trial court's order dated 7 January 2020 refusing to reject the plaint under Order 7 Rule 11. The court directed that the suit proceed to trial. It clarified that its observations are limited to threshold rejection stage and do not constitute any expression on merits. 5 practical implications and takeaways. For advocates and litigants, this judgment provides important guidance. Plaintiff's perspective. When drafting a plaint, You must clearly plead the cause of action, i.e., your right, the wrongful act omission, and the relief you seek. If including a claim for possession based on title, Article 65, alongside a claim for declaration, Article 58, you strengthen your position and reduce the risk of rejection under Order 7 Rule 11, d. Do not assume limitation or prior mutation litigation automatically bars your suit. Ensure you articulate when cause of action accrued and what event triggered limitation. Defendant's perspective. The Order 7 Rule 11, d. stage is not the place to lead evidence or argue adverse possession and limitation in detail. These are matters for trial if issues of fact arise. Defendants should preserve their limitation possession adverse possession defense but expect the court to reserve those issues for full consideration unless the plaint is clearly barred on its face. For courts, use the rejection power under Order 7 Rule 11, d. cautiously, only in cases where the plaint clearly fails to disclose a cause of action or is manifestly barred by law. Do not treat Order 7 Rule 11, d. as a device to decide disputed factual issues or defenses at the threshold. Where multiple reliefs are sought and any of them is within limitation, the plaint cannot be rejected solely because one relief appears barred. Strategic advice. For property suits involving title and possession, always consider including both declaratory and possession-based reliefs. Highlight in the plaint any periods of litigation mutation that affected accrual of cause of action, as this case did, mutation litigation ending in 2017, suit filed 2019. Use this judgment as a precedent in drafting applications resisting Order 7 Rule 11 rejections, particularly where mixed questions of law and fact exist, example adverse possession. 6. Conclusion. In conclusion, Karam Singh v. Amarjit Singh and Ors is a significant reaffirmation of the principles governing rejection of plaints under Order 7 Rule 11, d. CPC. The Supreme Court has clarified that the threshold power must be exercised on the face of the plaint alone. Defense documents, external evidence or detailed investigation of facts are not permissible at the Order 7 Rule 11 stage. Possession-based claims, Article 65, require trial of facts. They cannot be summarily rejected simply because a will or earlier mutation exists. If a suit includes multiple reliefs and at least one is within limitation, then the entire plaint cannot be rejected under Order 7 Rule 11, d. For practitioners, this decision is an essential tool, helping to resist premature dismissal of plaints and to draft robust pleadings in property title litigation. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.